everyone. Thank you. We're going to get started. Welcome, everyone. I'm Sophie Lavoie. I'm an associate with the Gender and Women's Studies program here at UNB. I'm also chair of the Culture and Media Studies department at UNB. I just want to acknowledge that all of our interactions here at UNB take place on unceded and unsurrendered territory of the Wolastoqey, Mi'kmaq, and Passamaquoddy people. The treaties for what governed that relationship were signed in 1725, and I always encourage people to think about how those treaties from 1725 affect the relationships that we have today and all of the actions that we carry out every day here on campus, and the effect that it has obviously on our students and the larger population. The Feminist Lunch Series is organized with support from the University Women's Center, which is UNB and STU, celebrating it was 20-year anniversary this year. The UNB Gender and Women's Studies program, UNB Libraries, which kindly lets us host the events here in the Innovation Hub, and the UNB Women's Alumni Association, which provides us with the coffee and refreshments very kindly. Today we're offering a very warm welcome to Sarah Jane Nussbaum from the Faculty of Law here at UNB. This is Sarah Jane's first time presenting with us. She's an assistant professor. She teaches criminal law, advanced criminal law seminar, legal ethics, and professional responsibility. Her scholarship critically examines the criminal law system's role in furthering systemic oppression, with a particular focus on sentencing and legal education. She holds a PhD from Osgoode Law School, a master's in law from the University of Cambridge, and a Juris Doctor and BA degree from the University of Saskatchewan. And she previously served as a law clerk at the Court of Appeal of Saskatchewan, which is quite a prestigious position. This afternoon, Dr. Nussbaum is going to give us a talk entitled "The Politics of Listening, Prisoners' Voices in a Criminal Law Class." I will let her present her topic, not give you the brief. Her talk will last about 30 minutes, and I'll be followed by a Q&A where you're welcome to ask her all of the pressing questions that her presentation will provoke. With that, welcome, Sarah Jane. Thank you very much.
Thanks, Sophie, for the very warm and kind introduction, and it's great to see you here today. As Sophie mentioned, I'm going to be talking about the voices that we listen to in law school, and in criminal law in particular, and thinking a bit about how we might extend those listening practices. And the starting place that we'll think about today is punishment. So when a person is convicted of a criminal offense, either after a trial or if they plead guilty, then the judge will impose a sentence on someone. And the sentence, there's a range of sentencing options. It can include fines or probation. Imprisonment is still a key mode of punishment in our criminal justice system. So one key question that has come up is the question of what goes on in prisons. And a law scholar, Lisa Kerr, has shown how what goes on in prisons is actually a bit of a mystery to many lawyers, legal academics, theorists of punishment, and legal educators and students alike. That when we think about what punishment's goals and practices are, we tend to not look inside the prison. We might think about how long should the sentence be? Is prison as a sort of abstract idea something that can be justified without actually looking inside the box? So Lisa Kerr articulates this as the prison being a black box in punishment theory. And what I want to think about today is exploring prison writing as one way to potentially learn a bit about what goes on inside prisons in a criminal law class. So why we might be interested in teaching law students about what goes on inside prisons, and why we might be able to use prison writing as one mechanism for that kind of learning. So for today, I'll touch on kind of 3 key points The first one has to do with the scholarship on the politics of listening. And so for this, I'll talk about two modes of listening that have been identified in this work. One is listening out, and the other is listening in. And I'll address what those both mean and how they relate to legal practice and education. Then I'll look at prison writing a bit more closely. I'll talk about a little bit about the history of the penal press in Canada, as well as then I'll turn towards the Journal of Prisoners on Prisons and a couple of examples of prison texts that I incorporated in my criminal law class this year. And then I'll address some opportunities and challenges that are raised by this kind of practice. So starting out with the politics of listening, this is a body of work that makes the key point, or basic point, that listening is political. Who and what we listen to is connected to relations of power and inequality. And to listen is not simply to hear another person speak, but it's about taking the responsibility to seek out voices, so people who have taken the time and care to share their voices. It's the other side of that, and taking the time and care to listen to what these folks have to say. It's also about being open to changing in response to what we hear. So sort of approaching different perspectives with an openness that what we hear might change our views or values or perspectives. And these key ideas come from a number of authors. Two places that summarize the key ideas behind the politics of listening are Leah Basel's work on the politics of listening, possibilities and challenges for democratic life, and Tanya Dreher and Anshuman Mondal's book on ethical responsiveness and the politics of difference. So we can distinguish in this kind of area of work between two different kinds of listening. One is listening in, and the other is listening out. Listening in has to do with listening inside the group. We could summarize it that kind of way. It's about paying attention to the voices that we normally hear, voices that share perspectives that feel familiar to us, that we maybe agree with, as well as it often involves listening to voices in power. So the kind of voices that carry privilege and power in our communities and societies, those are often the voices that are amplified, and those are often the voices that we hear. Listening out is about listening outside the group. So it's paying attention often, particularly to marginalized or oppressed voices. As well, it can include the idea of paying attention to different perspectives, which connects back with that idea of being open to change. We might not change our views or what we think about something, but we at least approach a conversation with that openness. And Kate Lacey, in her work on the labor of listening in troubled times, laid out this distinction between these two modes of listening. And one of the reasons why we might listen out is really connected with trying to reduce oppression. So the politics of listening, the scholarship in this area is very much focused on trying to recognize inequality and find ways to remedy inequality. Listening out involves listening to voices that have been marginalized and paying attention to those voices. Susan Bickford has written that if oppression happens partly through not hearing certain kinds of expression from certain kinds of people, then perhaps the reverse is true as well. So if part of the way that some people have trouble or face barriers in being able to live their lives the way that they want to, or experience their culture and communities in ways that resonate with them, that part of that comes from not listening to what they would value in their lives, then perhaps if we all take the effort to pay attention to those voices, then we can lessen oppression. So this leads to a general question of, well, then why don't we listen out? It seems like it's very valuable. It seems like it's something that we could all gain from. And Susan Bickford relatedly says that the riskiness of listening comes partly from the possibility that what we hear will require change from us. So that's one of the most important parts of listening, but it's also one of the vulnerable, scary, challenging parts. So that's just at the center of understanding some of the thinking behind the value of listening out and why it might not be taken up as much as we might think it should be. And so those ideas on listening out as a way to reduce oppression and listening out as something that's challenging come from Susan Bickford's foundational work on the politics of listening called The Dissonance of Democracy, Listening, Conflict, and Citizenship. So many of the authors working in this area work in areas like politics, international relations, media studies, arts, humanities. There's a little bit of emerging scholarship starting to come out in law reform and whose voices are listened to in law reform, as well as certain kinds of people's courts. But I want to spend a little bit of time thinking a bit more broadly about listening and lawyering. So starting out by thinking about what does listening actually involve for lawyers. I've just had a moment where something feels out of order on my slides, but I'm going to just carry along and hope that actually, is it okay if I take a moment to just take a peek at my slides? I had a third version, and I'm just going to do a quick check to see what happened for my order. No, I think I'm good. You know what? I think I am totally good to carry along from here, and I think it's going a little quicker than I had thought in my head. All right, thanks for your patience, everyone. All right, so for listening and lawyering, we can think about listening in, first of all, for this, as involving practices of listening primarily to appellate judges. If we think about who lawyers are trained to listen to, certainly still in the first year legal curriculum, when students get to law school, one of the key activities that they do is start reading appellate judgments. So judgments from, for example, the Supreme Court of Canada. And this involves, judges relaying the facts of the case and saying what the law is and applying the law to the facts. So similarly then, lawyers learn from that to approach clients with these particular kinds of goals in mind, knowing what the law is, having listened to judges, and then listening to clients and working to extract legally relevant facts from what clients say, trying to fit those into particular legal categories that the state has made, as well as then trying to identify legal solutions to those problems. Now, this opportunity to access this very sort of professionalized practice of listening for and responding to legal issues is possibly exactly what a client has come to a lawyer for, right? This access to this powerful kind of form of knowledge. But this kind of power relationship where the lawyer is the expert is not always in line with what clients are generally wanting. So there's been a recognition that lawyers need to listen out more. So listen more to their clients, where their clients are coming from, what their clients are trying to achieve through the legal process, or perhaps outside of the legal process. And Sarah Marsden and Sarah Buehler, in a study on a context where lawyers are working in marginalized communities, and they focus particularly on participants who are marginalized and how they experience law and access to lawyers and experiences with lawyers. And they found that these participants were recognizing that lawyers need to show compassion, respect, and a willingness to take time with the client. They identified that lawyers should show a nuanced attention to context, culture, and history. And they also showed that lawyers should be working to understand the whole story, beyond the immediately relevant facts. So I've just got the citation here for anyone who's interested. This is a study called Lawyer Competencies for Access to Justice, 2 Empirical Studies. So this call for lawyers to listen to the experiences of marginalized and oppressed members of marginalized and oppressed communities, we could see that as a bit of a call, this call for listening out. I think it connects well with the idea of not necessarily listening for a particular response, but listening with an openness to what you might hear from your client. And there has been some work addressing how lawyers might do this exercise of what we can call listening out. That language itself is not necessarily used, but there is some interesting work about developing lawyering practices that are approaching the practice with a less hierarchical kind of relationship between the lawyer and client. And one kind of practice for this is what's often called rebellious or community lawyering. And this involves an approach where lawyers collaborate with their clients. So instead of having the client share some information and the lawyer then just says, oh, these are the legal issues here, instead they work together to think about what kind of options could be pursued to pursue social justice, which is usually at the heart of these kinds of lawyering approaches. Another element of community lawyering in particular is an approach of considering the client's community. So rather than thinking just about your client's needs and interests, you think about the community as well. And Jessica Fireman has showed how this can be connected with prison lawyering. So for example, if you have a client who has been experiencing abuse by prison guards, then attention to the community of prisoners might inform the processes or procedures that you decide to follow. You might want to try to, address your client's experience of abuse right away, but you might also want to consider other forms of social activism or advocacy so that the other prisoners who might also be experiencing the abuse can experience some change as well. And this kind of lawyering also emphasizes thinking about the effectiveness of the approaches that are being pursued. So not just kind of going through the process and ending the file and moving along, but instead thinking ahead of time what kinds of consequences aside from maybe our immediate goal, what might happen here, and then seeing afterwards what are the effects of what's been done. So this connection between community lawyering and prison lawyering comes from Jessica Fireman's work from 2004 in a piece called Creative Prison Lawyering from Silence to Democracy. So if we continue to think about how might lawyers listen out, Deborah Parks has also articulated what she calls a prison abolitionist lawyering ethic, which is about thinking about how we can end prisons while still working with the legal system. So in prison abolitionism, there's often, a tension between pursuing reform within the legal system. So for example, bringing litigation on behalf of prisoners and tweaking how the prison operates versus trying to move towards closing down prisons or developing community supports outside of prisons. But Deborah Parks is of the view that both can be pursued together. And she points out in particular that lawyers who are interested in pursuing this kind of advocacy or practice, that they can use litigation and still maintain a focus on strategies to get people out of prison rather than making prison better. So there's space within sentencing law for lawyers to make these kinds of arguments before judges, or if the space doesn't exist, then there's a recognition that lawyers should try to maybe create some of that space. So this is a piece comes from a piece by Deborah Parks called Solitary Confinement, Prisoner Litigation, and the Possibility of a Prison Abolitionist Lawyering Ethic. So the next element that I want to talk about today is thinking more concretely about sentencing law and practice. So some of, I started out with, the ideas behind why we might want to pay attention to the voices of prisoners and what they have to say about prison is broadly connected with just foundational democratic values of paying attention to everyone's voices and giving them consideration. And then I touched on how some kind of broader models of lawyering that are a little more radical in nature from traditional lawyering might be used to achieve that. But what I want to turn to next is a very specific context where I think we can see elements of listening out in legal judgments themselves in a very recent context, which has to do with prisons and the COVID-19 pandemic. So during the pandemic, prisoners experienced a lot of challenges. So they were faced with not being allowed to visit with anyone. They were not allowed to transfer between institutions. So for example, if someone was at a point where they were eligible to transfer from, for example, a maximum security to a medium security institution, those transfers were put on hold. They were not able to access gyms or libraries or common spaces. Rehabilitative programs shut down. Sometimes they had to go into medical isolation, so further confinement within an experience of confinement, as well as there were COVID outbreaks happening at an increased rate from among the general population in prisons, which led to, of course, some illnesses and some death. So a lawyer named Chris Rudnicki looked at this context and looked at how judges were responding to this. And there are instances of cases, there's a strand of authority in Ontario where judges were reducing offenders' sentences to account for the increased suffering that they would be experiencing once incarcerated. So normally in sentencing, a judge will determine a fit sentence. So they will think about how serious was the offense, what kind of impacts did it have on victims, for example, how blameworthy is this accused person for the offense that took place, and then they'll arrive at a fit sentence in keeping with what kinds of sentences have been imposed for similar kinds of conduct and similar kinds of circumstances. And in this pandemic context, there were some judges who would arrive at a fit sentence and then they would look at what was happening in the prisons and say, this suffering is going to be increased for you, so we will try to account for that by lessening the length of time that you spend in prison. So it was a way to sort of look inside the prison and see what was happening and try to respond to it in some kind of way. So we can see it as a bit of an example of lawyers and judges starting to listen out. It's not, this was not a uniform practice. There are also examples of judges who felt they did not have the authority to do that kind of sentencing reduction. And then even among those cases where this is practicing, where this is kind of carrying some weight, it's also notable, I think, that there are still hierarchies involved in the kind of listening that's happening. So it's been noted that there was a very influential affidavit that an epidemiologist prepared and made widely available to defense counsel, and that was then used as the evidentiary foundation addressing what the prison conditions were like and what the risks of contracting COVID were like in the prison. So we can still see that the sort of legitimization of thinking about what's happening in prisons is coming from expert knowledge rather than the sort of lived experience of prisoners. But at the same time, it might be viewed as something that helped increase access to justice for prisoners in the sense that now an offender would not have to go out and gather that evidence on their own if this affidavit is something that's widely available. So instead of having to be burdened with making that case to the judge every time, they have access to some information that judges will be receptive to. So Chris Rudnicki writes that in this context, he draws on Lisa Kerr's metaphor of the black box that we started the talk with, and he writes that the black box of punishment theory is at last open. The task now is to look inside. So he sees this as a possible opportunity for extending this kind of practice even beyond pandemic contexts. So seeing space in sentencing law itself for judges to think about what's actually happening in prison and how does that affect someone's experience of suffering. So this piece is called Confronting the Experience of Imprisonment in Sentencing, Lessons from the COVID-19 Jurisprudence. So with that context in mind, I'll now turn to prison writing in particular as one potential mode for bringing the voices of prisoners into a criminal law class. So reading prison texts, and prison texts or prison writing is basically writing written by prisoners. And reading these texts can offer students some space to practice this skill of listening out. This kind of task or practice has the potential to disrupt these usual listening practices that we undertake in law school of listening to judges' voices. By reading prison texts, we listen to prisoners. And in one of the examples that I'll describe below, we also listen to a conversation between an incarcerated student and a non-incarcerated student, both of whom were practicing listening out of their own day-to-day communities by participating in an educational program where they were peers with one another and then creating a text based on a back and forth interview that they did together. So I tend to think that writing produced by prisoners has the potential to teach students that prisoners' voices matter, that prisoners' voices are diverse, and that when paying attention to prisoners' voices, we might learn something that challenges us to change the way that we think about prisons, the criminal justice system, or the people involved. So just as a little bit of background, I'll just share a few notes on the penal press. So this was a sort of international network of prison journals or newspapers that were really flourishing in around the 1950s and 60s. The writers and editors of these magazines were prisoners. And the writers, who were prisoners, engaged in a practice of both criticizing and supporting the prisons. And those journals that were part of the international penal press were able to exchange their writing between prisons. So it wasn't just within one institution, it actually involved kind of moving beyond prison walls by the journals that were part of the press would publish exchange columns with publications that were coming out in the other journals. And there were also outside subscribers like libraries that would receive copies of these publications. These journals are really fascinating, partly because they were supported by prison authorities themselves, including with financial support. There is also research showing that the authorities were actually involved in selecting who got to be the editors of the prisons. And it was sort of at a time where there was optimism around prison reform. And so it was sort of a mode for showing the legitimacy of prisons and the sort of rehabilitative ideals that were connected with the prison. And this sort of fine balance between criticism and support I found really interesting as well, even for which publications were accepted in the journals. There were also efforts to try to make sure that the people who were writing were portraying prisoners in a sort of positive light, especially since they were going to some outside subscribers as well. But this, mechanism or way of writing and publishing prison writing did not last for a long time. By the end of the 1960s, the prison reform promises were not being fulfilled. So prisoners were becoming disillusioned with promises of employment prospects, rehabilitation, and so the interest kind of turned towards wanting to criticize the prison more, and then that led understandably to less support from prison officials, less financial support. So basically, the prison press, or the penal press, sort of fizzled out. More radical and underground presses began to develop at that time. And then by the 1980s, we have a modern day successor, which is the Journal of Prisoners on Prisons, which I'll talk about next. But just before that, I wanted to highlight another thing that we can kind of take away from the penal press as part of the context. Scholars who have researched into this area have shown that on the one hand, this writing, it can be sort of a mode of listening out, right, to voices that have been oppressed, and it can show some insights into that. On the other hand, oppression is reproduced within this writing, as there was a lot of racist rhetoric that was contained within the prison writing in the penal press. And so we see sort of the most marginalized of the marginalized prison population experiencing sort of not having a voice or being portrayed through racist stereotypes. So the two authors working in this area are Robert Gaucher and Joshua Mitchell. So those are a couple of pieces that I consulted in thinking about that history of the penal press. And I dug into that history because the journal that I used for the sources of prison writing that I assigned in my class is called the Journal of Prisoners on Prisons. And they identify as, being within the tradition of the penal press. Now, developed in the 80s, this journal is run by editors who are university professors, but the pieces that they publish are primarily pieces written by prisoners themselves. And then they go through an academic peer review process also. And the journal describes itself as bringing the knowledge produced by prison writers together with academic arguments to enlighten public discourse about the current state of carceral institutions. So it's about recognizing the value of experiential knowledge in shaping conversations around penal policy. And then we have my examples, which came from the Journal of Prisoners on Prisons. And so in my first year criminal law class, I assigned two pieces. So this first one is a piece by Vanessa Slater and Jamar, and it's called A Bridge Interrupted. And this piece was written in a special edition of the journal on the Walls to Bridges program, which is a program in Canada that involves incarcerated students taking a university class together with non-incarcerated students. And the students come together in a prison and take a class for university credit together. So an important feature of this program is that it's not a mentorship program. Both what are referred to as inside students and outside students are coming together as peers to learn. And there will be some sort of theme to the course. This theme of the course that Vanessa Slater and Jamar took together was on resilience. And in this piece, Vanessa Slater and Jamar reflect together on what they learned in their class environment. They took the class in, I think it would have been the winter term of 2020. So they had a number of classes all together, and then the pandemic came and they couldn't meet together anymore. And so in the summer, they did a phone call interview together over a series of phone calls where they asked each other questions and then recorded and transcribed what they discussed, and that's what forms the basis of this piece. And I think that the piece really shows an example of listening and moving towards equal relations. So they talked about the shared space and learning environment that they had created as a class. They talked about shared laughter. In terms of prison, Jamar asked Vanessa, so Vanessa was the outside student, and Jamar asked Vanessa, what did you learn about day-to-day life for us inside students? And Vanessa responded that she learned about challenges in accessing the library, about the challenges in accessing educational programs or computers or professional learning opportunities. about how expensive phone calls are, how noisy it is inside a prison, how food can be of really poor quality. So we can see listening happening within their conversation, and as well as within the students' practices in the prison of paying attention to what was going on inside. And Jamar felt that the program gave students, inside students, the opportunity to learn from outside students and see how people who are not incarcerated are having conversations and thinking of how they're thinking about things and how to interact. So finding it to be a way to create genuine friendships, as well as to perhaps transition to being outside of prison again in the future. And they talked as well about the challenges of the pandemic. So Jamar mentioned, for example, that he wasn't able to pursue his goals. He wasn't able to even express gratitude to everyone involved in the program. And he had been hoping to take a psychology program after, and that had been put on hold. So that was one example of showing listening kind of between two students and learning about the prison through that process. And the other piece that I assigned is called Presentiment, and it's by Nicola. And this involves both a poem that Nicola wrote as well as a picture that she drew. And she drew this during the pandemic as well. This was the back cover, actually, of that special edition on Walls to Bridges. And when you look at the picture, you can see closely in the distance the sort of the razor coils on the prison fence. You can see this big oak tree that she refers to in the poem and describes as looking not quite right. So it's normally was a place of offering shade and protection and a place for birds and squirrels to live and enjoy themselves, and nothing was looking like that during the pandemic. So we can see as well the absence of the wildlife around there. We just see some yellow leaves and maybe a couple berries. And she talks about drawing on this oak tree at a time when everything's looking and feeling different, to draw strength and to be patient and to offer support to others. And at the very end, Nicola writes, "Please don't forget us in here." And choosing these two pieces was a challenging task, which I think actually also goes to show just the kind of strength and perseverance of prisoners. The fact that there is actually so many texts that I could have chosen from just in the Journal of Prisoners on prisons alone, particularly when considering the kinds of conditions that prisoners would be writing under, including, for example, not having access to the internet or facing difficulties in accessing libraries and books. But in a broader sense, what I thought I'd turn to now are just some kind of larger reflections on thinking about what this kind of practice raises for criminal law teaching and learning. So I don't want to overstate the possible effects of reading a couple of pieces on prison writing in one criminal law class. I think there are a few things that suggest that this might not have huge impacts potentially, right? One is just the extent to which appellate case law is still dominating the law school curriculum and my course even as well, right? I still assign a lot of appellate cases, and so even just in looking at, comparative weighting, it's possible that students might see this as not being as important as the cases that are otherwise being assigned. Prison writing also, or these pieces that I've shared, capture just a couple snapshots of life inside a prison that are very unique to the authors themselves. Now that's part of what gives it value, particularly I think I was thinking here a bit of a feminist standpoint, theory perspective, that lived experience is knowledge that is valuable, but it also means that we're seeing some experiences when we know that prisons themselves vary widely from place to place and in time, and individuals' experiences might vary within them. It's also possible that reading texts rather than witnessing a prison or a person in real life might lead to translation issues. So it could reinforce potentially divisions rather than breaking them down. I also find myself needing to reflect a bit on how to teach prison writing. You know, how much do I share about the overall objectives or possibilities? What material do I pair it with? And how do I even talk about it? It's very different from most of the material that I teach. So it's something that I'm still reflecting on. I can also find myself thinking about whose voices are included in prison writing and which ones to assign. There are dimensions of inequality that might be reproduced in this kind of context, and how could I take that into account? And of course, what I haven't addressed are any messages that students might be taking away from this. In trying to think about this in the classroom environment, I'm thinking about it as one possibility beyond clinical context as one example, where students are exposed to real life clients, and studies show students often in that environment start experiencing tensions in what they thought they knew about the law and what the law actually involves. So this might be one little way to introduce students to a bit of that kind of dimension of the law and law's experience and practice at the beginning of their education. I apologize, I see I've gone a little bit over time. Thank you very much for listening today, everyone. I really appreciate it.
All right, thank you, Sarah Jane, for a fascinating talk, probably something that many of us didn't know very much about, and very well introduced. I'll open the floor up to questions or comments that anyone may have. Yeah, Julia?
I have just a very general question to start things off. How do the students react?
Oh, this is interesting. Yeah. So I don't have a lot of, so I have a kind of a couple sources where I might get some of these responses from that are not part of my research. So if I can bracket and talk as an instructor in it, this wasn't like something I got any research ethics approval for, that kind of thing. So it's not part of this project. But in the class itself, the students kind of broke up into small groups and spoke about these pieces, as well as I did assign along with it a Senate photo essay, which was created of Canada's East Coast prisons, led by Senator Kim Pate, and it had pictures of prisons on the East Coast. And so there was perhaps a little more conversation when I was going around the classroom, I found, about what they were seeing in the pictures, some being not surprised and feeling sad kind of about that. I do remember there were a few students who were noticing, oh, I had heard about bad prison conditions in the pandemic. You know, it was something they had kind of maybe heard about in the news or something, and then were curious about, reading a bit about people's experiences like that. I also assigned a reflection assignment for the materials on sentencing and punishment generally for the course. And so for that, students could pick any piece of material that we covered in that unit and write a reflection on it, on what they were learning, what their reactions were to it, how connected with other material from the course. So a number of students wrote on some of the cases that we covered or the legislation. There were some students who wrote on the prison text, and those were, all of the reflections were thoughtful to read. I won't go into like a lot of detail on the students' assignments, but I think picking up things, if I can speak generally, like, oh, kind of cool that students are learning as peers with students who are in prison. So I think that kind of dynamic, that like a non-mentorship relationship with prisoners, was something that stood out to students, as well as just in terms of kind of experiencing the emotions that came along with reading about what it might have been like in the pandemic, when we're all kind of familiar with having some form of confinement, or being limited in where we can go and who we can see, but just seeing how significant it was imposed, what was imposed and what was felt among prisoners. Yeah, thanks. Yeah.
Nicole, yeah?
Yeah, great talk. For those of you who don't know me, I also teach at the law school with Sarah Jane, which is great. And I clerked at the Saskatchewan Court of Appeal, so I'm happy to hear that it's so prestigious. Good for us. Okay. I think students, especially in law school, I think students everywhere, but they tend to confuse authority with being correct. And then how do we critique people like judges from the Supreme Court of Canada who have X, Y, Z to say about things? And now you're introducing these materials that are not authoritative at all, right? And they don't look like any kind of other sources or whatnot. So that I find very interesting that you're bringing those materials into your seminar and how they're reacting. But how do you deal with that authority getting mixed up with, but that's right, and then like what do I do on the exam? Like this other stuff's kind of cool, but it's still not what I really need to know as a lawyer.
Yeah, thanks, Nicole. This is a great question, right? I think this is a huge challenge for anyone, those of us who kind of look at law and think, there are some problems here, but also you need to learn it, right? So it's like, I think thinking about law as teaching, language and tools that really give access to like some, very other powerful institutions, right? That can be used to possibly make change or possibly not. In terms of that kind of balance or thinking about how to approach that, I don't think I have any real answers to it. So I have maybe some thoughts, which would include, I think, just encouraging students to see that, the law might have that authority, like you're saying. It doesn't mean we all agree with what it is. In terms of creating space for that, one thing I do pedagogically is I always have an essay question on my exam, and I tell students about that so they know going in, and that they can know that there is a space for I want to hear what you think about what, whatever the question is asking about. For problems, I guess we can point out spots where there's maybe a little gap in the case law, something that hasn't been answered yet, so there might be space to push that law in one direction or another. What the effects of that will be, it's not, guaranteed that will lead to, meaningful change. I think that if I were to think broader, now I didn't really explore the COVID case law in this class with the students, but I think that analysis is an interesting place where thinking about different knowledge, different experience, and how it might have an impact on sentencing itself is kind of a cool little spot. And I guess sentencing generally is an area where the law at least purports to being open to hearing more about people's lived experiences. So in trying to find a fit sentence, but it's still kind of translating into a legal space. But I think that Chris Rudnicki, at least in that article, tries to make the case that the judges who are looking at conditions of imprisonment as being something that you can factor in when sentencing, that there is even Supreme Court jurisprudence that supports that. So I feel like I've gone on a couple tangents, but it's a great question. I think just like something that's always there, even if I feel like I can't answer it. Yeah, thanks.
Should I ask my question?
Yeah.
No, Jane, go ahead.
So the writings that you picked were women.
I think there were at least women involved. Yeah.
Does that show up more? Are women more represented, even though there are less women in prisons, in the writings that you've looked at?
Thank you. Yeah, that's a great question, because one thing that I kind of left off and didn't get into a lot was gender dimensions. But I was thinking a bit about gender dimensions when I chose the pieces. I'm not sure that it's necessarily more frequent. I would have to do a closer look. I actually thought on the whole I was seeing more, at least from a quick glance, which might not be informed, more writing written by men actually was what I tended to see as more of the common thing. Although this particular journal does seem to be trying to have like special issues and stuff. There was one special issue on, I think, reproductive justice in prisons, and I think that focused a lot on women. And so there are strands of it in there, but I'm not totally sure that there's more representation or just that it's starting to come out more now. But I would be interested in looking more closely at that. One thing that I find is challenging is that even I worry about my own, like how to even do that analysis when it's not clear, and then I feel like I'm just using my sort of assumptions about what name lines up with which gender and not actually knowing. And I actually found myself thinking that while I was talking today. In a couple moments I realized, I was like, I actually can't remember, I didn't go back and check. And so that's also a dimension where if that's not included in the author's biography, I'm not sure how to deal with that and think about that, as well as like racial dimensions as well was something I thought, how would you think about that in this context when you might not know some, perhaps a bio might refer to someone's racial background or ethnic background, but sometimes it doesn't, and so there are parts there that I think would add an interesting intersectional kind of dimension, but I'm not sure how to go about addressing it yet. Yeah, thanks.
Yeah.
Oh, sorry, was there another hand?
Yeah.
Oh, we're both looking at the
twice.
same person.
So one thing that came to my mind, I worked in a custody setting for 3 years. What the Walls to Bridges program results in, like, does it result in some, like, a degree or a diploma, some variation? Just like a thing that I do not agree with, but the current realities of sentencing and parole and judicial ramifications post-incarceration, when the individual said they were interested in obtaining like a psychology program, just the realistic possibility of entering the social services with a federal record at that time. I think back to a lot of conversations I had to have with youth who were looking at adult sentencing, that some of their aspirations weren't necessarily realistic. So how does that work in conjunction, say, with like skilled trades programs? Again, not a stance I agree with. I'm very, very pro rehabilitation and chances of opportunities and to pursue the humanities and social services even with a record. But just that taking the place of, say, like a skilled trades program that could result in realistic prospects of employment post-incarceration.
Yeah, thanks, Zane. That's a great question. In terms of the Walls to Bridges program itself, the students will gain a credit for that course. So it's like a one course credit. So whatever that would be, if it's like 3 credit units or whatever, that's what they would get. I don't know more broadly. I do remember recently coming across something that was writing about how we don't have enough access to higher education programs in prisons, with the Walls to Bridges program being sort of recognized as one exception, but that it doesn't seem to be, I'm not sure what that psychology program, what Jamar was referring to exactly there. And then in terms of thinking about what kinds of avenues might students take after that, that's something I would have to look further into and see. Are there also trades programs that maybe they do concurrently or can make the choice between? And then I have seen there's, and I'm sure there's more than one author, there's someone, and her name is escaping me right now, but who has published in the Journal of Prisoners on prisons and was formerly incarcerated and then was pursuing graduate studies in some social sciences discipline. Now, I don't think this is connected with Walls to Bridges, but it's like one example of someone kind of pursuing further education. Your point about what kind of job prospects would there be, that's a realistic point that makes sense to factor in, even if we don't like those realities. So yeah, good comments and things I'll keep in mind when continuing to learn about this area. Thanks.
Maybe I'll make my comment to close this off. I just think this work that Sarah Jane is doing is so important, because I think our students come into classes with a cultural representation of justice and policing that comes from popular media that's often very biased. So they come in with a very strict thing, and then they go into law classes where they're really reading appellate cases and they're getting something completely different, but also very one-sided. So I think, listening out through, prisoner voices is very important. And I know, coming from culture and media studies, that's a huge kind of concern, right? That they're not getting those other voices in the same way. Before we thank Sarah Jane for last time, I just want to remind you that our series is going to be back next week. Same time, but not same place. So if you're coming to Julia's talk, unfortunately this room was not available, but we will be in Tilly Hall, room 28, which is just 2 buildings down, and you're more than welcome to come. Julie's talk is going to be titled Sinews of Nazi Empire, German Female Military Auxiliaries in World War II Europe. And it promises to be a very interesting talk on Julia's new area of research. So we're really looking forward to your talk, Julia. If you want to stay abreast of all of our events, and our Feminist Lunch will be back in the fall, you can like our University Women's Center page on Facebook, and all of our events come through there. And please invite your friends, colleagues, peers to come to our events as well. Now, if you'll join me thanking Sarah Jane, and have a good afternoon.
Thank you so much, everyone. This was a pleasure to share this work with you. It's early new work, so I really appreciated this space.